The next session that we have is session 3, a survey on the latest judgments of the International Court of Justice. The chair of this session is Ms. Loretta Malintoppi. Ms. Loretta Malintoppi of 39 Essex Chambers sits as an arbitrator in the Latin America and Asia Pacific regions. Aside from being an arbitrator, she also regularly appears as counsel and advocate in state-to-state disputes before the ICJ and ad hoc interstate arbitrations.
Thank you very much, Tara. And hello to everyone from Singapore. Hello to the people at CIL, and thanks for inviting us to this very important event. We're very fortunate to have a stellar panel of public international law specialists, and I'll briefly introduce them. Davinia Aziz, who's senior counsel at the Attorney General's Chambers, the International Affairs Division, and is presently a minister counselor at the Singapore mission in The Hague. Rodman Bundy is a senior partner at Squire, Patton, Boggs in Singapore and has practiced in the field of public international law for over 35 years, working as counsel and advocate for governments before the International Court of Justice, international tribunals in interstate disputes, and investment and commercial international arbitration. Sir Michael Wood is at present a member of the International Law Commission, but was for 35 years the principal legal advisor to the Foreign and Commonwealth Office. After leaving the FCO in 2006, Sir Michael has been extremely active as counsel and advocate in cases before the court, the European Court of Human Rights, ITLOS, and interstate tribunals. But turning to our overview of the court's activity in the past year, the court has had a very busy year in which it has delivered judgments and an order in provisional measures in 7 cases, in spite of the very trying circumstances of the pandemic. The court has held virtual meetings and hearings and has adapted its working methods to the need to work remotely. It has also amended its rules to make sure that a hearing can be held or a reading of a judgment can be read by video link if necessary due to the health situation or other extreme circumstances. The cases that we would like to focus on today are judgments and 1 order on provisional measures, and they are the following. The judgments in the 2 cases on the appeal relating to the jurisdiction of the ICAO Council between Bahrain, Egypt, and the UAE and Qatar, which was rendered on 14 July 2020. The 2 judgments of December 2020, the first on jurisdiction in the matter of the arbitral award between Guyana and Venezuela, and the second on the merits in the case between Equatorial Guinea and France, which is called Immunities and Criminal Proceedings. There was also a very important order on provisional measures in the Gambia Myanmar dispute of 23 January 2020. February was a busy year with 2 judgments, the first on the 3rd of February in the alleged violations of the 1955 Treaty of Amity between the United States and Iran, and the judgment of 4 February in the application of the Convention on the Elimination of All Forms of Racial Discrimination, the 3rd Convention, the case between Qatar and the UAE. But the court has not limited its work this year to these various activities of judgments. It also began deliberations in 2 cases in the armed activities on the territory of the Congo between DRC and Uganda, and in the maritime delimitation in the Indian Ocean between Somalia and Kenya. There was 1 new case brought before the court last March, the case between Gabon and Equatorial Guinea, which is a dispute having to do with the country's maritime and land boundary, as well as sovereignty over certain islands. Other issues that deserve a quick mention are the adoption of a new article, in Article 11, on the resolution concerning the internal judicial practice of the court in December of last year. It's an article which is important because it provides for the establishment of an ad hoc committee of the court composed of 3 judges, which will assist the court in monitoring the implementation of the provisional measures that it indicates, which is an important aspect that the court has been discussing for some time. Another important trend, I think, in the work of the court and practice of the court was the appointment of 4 experts in 1 case, experts appointed proprio motu by the court. The experts are going to opine on the question of reparations due to the loss of human life, the loss of natural resources and property damages in DRC versus Uganda. The court has resorted more and more often to its power to appoint experts under Article 50 of the statute, so this may be a new trend. And finally, one thing I'd like to mention before I give the floor to our speakers is a new amendment to Practice Direction 3. The court has always been very importantly stressing the fact that the parties should keep the written pleadings to as concise as possible in a manner compatible with the full presentation of their positions. And with this new practice direction, the court has for the first time put a maximum limit of pages on the annexes attached by a party to its pleadings, and that limit will be 750 pages in total, unless the court decides that a larger number is warranted. And it'll be interesting to see how the parties will comply with this new direction. Two other important events, of course, in February of this year, Judge Joan Donoghue was elected president of the court. And in January of this year, Judge Nolte was sworn in as a new member of the court. Finally, before I give the floor to our speakers, I would be remiss if I didn't also mention, while speaking of events of significance in the life of the court in this past year, the very sad news of Judge James Crawford's death on 31st May. I speak on behalf of all of us on this panel and certainly many of the participants to this conference when I say that James will be greatly missed, not just for his extraordinary contribution, his dedication to international law during this extraordinary career of his, but also on a very personal level as a friend and a colleague. So moving on to our panel, before I give the floor to Sir Michael, I just wanted to mention the fact that we will also touch on two cases which are not, strictly speaking, not at all ICJ cases. They're two awards in cases, one before the Annex 7 Tribunal in Enrica Lexi, Italy, India, which was rendered, the award was rendered in May of last year, and then also the jurisdictional judgment of January 2021 by a special chamber of ITLOS in the Mauritius Maldives case. And I believe Rodman Bundy will briefly review those cases. But first of all, let me give the floor to Sir Michael for him to discuss the ICJ judgment in the arbitral award case between Guyana, Venezuela, and the order and provisional measures in Gambia, Myanmar. Michael, the floor is yours.
Thank you very much, Loretta, and I thank the organizers of this event for inviting me to take part. It's a great pleasure to do so. As Loretta said, I'm going to talk about two of the decisions of the ICJ in the last year or so. First, the Gambia-Myanmar provisional orders measure, and secondly, the arbitral award case between Guyana and Venezuela. I make it clear at the outset that I have not been involved in any way in either of these cases, so I feel free to speak about them. But in the very short time available, I won't obviously be able to say very much. The Gambia-Myanmar genocide case was, of course, a high-profile case, and I'm sure most of the participants, all of the participants perhaps, have followed it closely. But just to recall, the order on provisional measures was made on the 23rd of January 2020. Since then, the Gambia has submitted a memorial in accordance with an extended time limit. And on the 20th of January 2021, just a few months ago, Myanmar filed preliminary objections to the jurisdiction of the court and the admissibility of the application. I just note in passing that these preliminary objections were filed very shortly before the military takeover in Myanmar on the 1st of February 2021. So any questions there might be about the representation of Myanmar were not raised by the filing of those preliminary objections. I'm not aware of other developments. As usual, there's very little on the court's website. I don't, for example, know what follow-up if any, there's been to the court's decision that Myanmar should submit reports to the court on the measures taken to give effect to the order. By my calculation, Myanmar should have submitted 3 reports by now, in May and November last year and in May this year. The Provisional Measures Order is the latest in a long line of decisions from the World Court on provisional measures. It was unanimous, including both ad hoc judges, and so perhaps it carries particular weight. It seems to me that the basic requirements for provisional measures are now well established in the court's jurisprudence, a jurisprudence that's likely to be followed by other international courts and tribunals. And I think the decision in the Gambia-Myanmar case of January last year usefully confirms and consolidates earlier case law on provisional measures. And perhaps it doesn't add a great deal in that regard. Only Judge Shui differed on 1 or 2 aspects of the basic reasoning. And interestingly, Judge ad hoc Kress, appointed by Myanmar, didn't do so, though he seems to have been prepared to go even further than the court in rejecting Myanmar's argument about the effect of the seriousness of the allegations. Of course, having said that, there's all to play for at the merit stage, not least, it seems to me, on the question of genocidal intent. Now, in certain respects, the court dealt with a number of points of interest that won't be lost, I think, on practitioners and observers of the court. And I'll just mention 3 very quickly. Firstly, the court had some interesting things to say about the Genocide Convention. The Genocide Convention seems likely to remain a fruitful basis for litigation in the foreseeable future, alas. It clarified, for example, that Articles 8 and 9 of the Convention can be said to have distinct areas of application, and went therefore a bit further than it had done in a passing reference in the Bosnia Order from the 1990s. Secondly, and I think this is significant, the court placed considerable weight on the facts and opinions set out in United Nations reports, as well as in United Nations General Assembly resolutions on the situation of Myanmar. And indeed, what was said by the parties in the General Assembly debates. This was both for determining whether there was a dispute and on the question of urgency. And it seems to me that Counsel for the Gambia used these materials very effectively before the court. I think there are lessons there for states faced with possible legal proceedings about the significance of facts and opinions set out in UN reports, though of course one can't generalize, and about how to establish or avoid establishing the existence of a dispute. And third, and perhaps the most interesting point, concerned what the court had to say about Gambia's standing to bring a claim under the Genocide Convention, building to some extent on the Belgium-Senegal case, which of course concerned the Torture Convention. The court seems to have given some impetus and encouragement to non-specially affected parties bringing cases under human rights treaties. Judge Shui critiqued this point in her separate opinion, and I think that if you read that separate opinion, you can see the importance that she thought should be given to this judgment, this decision. Presumably, we'll see more on this point when we see how the court handles the preliminary objections. There's also the question whether the Gambia, other states will join the Gambia in bringing the case. You may recall that over a year ago, Canada and the Netherlands issued a press release expressing their joint intention to intervene in the case. but so far as I know, they haven't followed that up yet. The issue that Judge Shui draws attention to is really the significance of Article 48 of the Articles on State Responsibility, and whether that reflects customary international law. It's interesting, especially at this sad moment, because Judge Crawford is on record as saying that his greatest achievement, his greatest contribution in the field of international law was indeed Article 48 of the Articles on State Responsibility. So I do think that's quite significant. Now I'm going to turn to the second case, and I shall be much briefer on this, the arbitral award case between Guyana and Venezuela. I think it turns very much on the facts, so I won't say very much about it, but it does illustrate to me how important history is for international lawyers. Of course, this concerned an arbitral award given 120 years ago and an interpretation of a treaty that was negotiated well over 50 years ago. So as we work as international lawyers, we should bear in mind that perhaps in 100 years' time or even more, what we do may be subjected to scrutiny by international courts. The judgment turned entirely on the interpretation of a provision in a bilateral, trilateral, bilateral treaty from 1966, and in particular on whether the provision conferred jurisdiction upon the court such that it could be seized by unilateral application. In essence, the parties had agreed in this treaty that they would go to the International Court of Justice, or they would go rather to a dispute settlement process determined by ultimately the Secretary General of the UN. Whether that meant that either party could go by unilateral application was the issue before the court. And by a majority, they read the treaty as saying that you could do that. This is, there were some powerful dissents, however, which I commend to you, by Judges Abraham, Benuna, Gevorgian, and above all, I think Judge Guyer's dissent is very, very interesting. But the real issue in the case is how much care the court should give to the requirement that parties consent to the jurisdiction of the court, and consent clearly. And you might wonder whether they had consented clearly in this case. It's an interesting question whether the court should err on the side of caution where it's not clear that consent has been given. And I just leave you with that thought. There are other interesting points, but I think that's the main one.
Thank you. Rod, over to you.
Let me start, since this is supposed to be a panel on the ICJ, with two non-ICJ cases, since I'm a bit of a rebel without a cause. I want to briefly speak of the Mauritius Maldives case. It's a maritime delimitation case brought by Mauritius against the Maldives, and Mauritius was clearly building on the court's advisory opinion in the on the Chagos matter, as well as the Chagos arbitration and UN General Assembly resolutions on the matter to bring the case. It brought it as an Annex 7 arbitration under UNCLOS. The Maldives raised a series of preliminary objections which were decided recently. All of those preliminary objections, which were based on the argument that the tribunal had no jurisdiction over sovereignty issues. The Chagos involved a sovereignty issue. A related argument that the UK was an indispensable third party, drawing on the monetary gold principle. Arguments that the General Assembly resolutions are not legally binding, and that the ICJ's advisory opinion and the arbitration did not really resolve the matter, allowing the Mauritius to be considered the coastal state with respect to the Chagos and the delimitation against the Maldives. None of those preliminary objections to jurisdiction were successful. All 5 were rejected by quite substantial majorities in each instance. Now, without getting into the merits, because the case will proceed to the merits, and I'm not involved in that, there was one interesting aspect that I think is beginning to be a bit of a trend in cases under the Law of the Sea Convention. Now, this was a case that was brought under Annex 7 because that was the default position under Article 287 of the Convention, since the 2 parties did not have matching declarations stating a preference for dispute resolution of a forum. But the case was then, by special agreement between both parties, transferred and turned into a special agreement case before a special chamber of the International Tribunal of the Law of the Sea, a 9-member tribunal. So it is now an ITLOS case, not an Annex 7 case. Now, this is interesting. You may recall that in the Bangladesh-Myanmar maritime delimitation case, Bangladesh brought that case under Annex 7 as well. It was their only means of unilaterally seizing a tribunal. And then the parties, by special agreement, agreed to transfer what had been an Annex 7 case to the full Hamburg Tribunal, which rendered its judgment on the delimitation case later on. And then more recently, we had the case brought by the Côte d'Ivoire, brought by Ghana against the Côte d'Ivoire for maritime delimitation between those 2 countries. And once again, Ghana, which had originally filed an Article 298 opt-out declaration, which would have precluded it from bringing a unilateral application, withdrew that declaration and commenced an Annex 7 arbitration. And once again, the parties met and agreed by special agreement to transfer that case to ITLOS, again to a special chamber of ITLOS, a 5-member chamber in that instance, as opposed to the 9 members in the Mauritius Maldives case. So that's 3 times we've had maritime boundary cases started under Annex 7, but have wound up going either to ITLOS or to a special chamber of ITLOS. Why is this happening? I'd like to posit a couple of reasons, because they may be significant for states that find themselves in these positions. The first is a question of costs. If you go to arbitration, Annex 7 arbitration, you have to pay the arbitrators. First of all, you have to go through a selection process for them. You have to pay them. You have no registry or administrative secretariat. Frequently, parties will use the PCA for that, which is very good at these sorts of things. But there are some significant costs involved, which obviously don't arise if you go to either the ICJ or to ITLOS, both of which have sitting tribunals and very competent registries. I think that's one factor that's entered into the decision to transfer these cases. And then when they go to a special chamber, of course, the parties have to agree on the composition of the special chamber. Another might be in the early days of ITLOS, it never had a delimitation case. And I can remember probably 20, 25 years ago, a member of the tribunal convening a bunch of practitioners in London saying, how do we get delimitation cases? And our answer was basically, you're a victim of your jurisdictional limitations built into the convention. But then Bangladesh, Myanmar changed that. And I think the tribunal demonstrated that though it carved out some new ground, because this was the first case of an outer continental shelf delimitation beyond 200 miles, and the creation of some gray zones where one state had column of water rights and another state had continental shelf rights. In terms of delimitation, it basically followed the principles that had been articulated over the years by the ICJ. And the same thing happened in Ghana, Côte d'Ivoire. So I think there's a growing confidence in states of the capability or the ability of ITLOS to deal with the limitation cases, and to do so in a manner that doesn't, in a sense, depart from some of the well-established rules that have developed over the year. That's all I wanted to say on that matter. On the Enrique Lexi case, it was an interesting case. An Italian tanker en route to the Middle East, to Egypt, was transiting through India's exclusive economic zone when it was approached on the radar and then visually by what appeared to be a small fishing boat, which kept on the same bearing towards the tanker. The tanker had a contingent of 6 Italian Marines on anti-piracy duty stationed on it. When this small boat got within about 500 meters and less of the tanker, the Marines fired what they said were warning shots, several blasts from automatic weapons. The small boat ultimately veered off and passed astern of the tanker, but it wound up that 2 fishermen on the boat had been killed. And after investigations, the Indian authorities contacted the Enrique Lexi, asked whether it had been involved in an incident. The Enrique Lexi captain verified that it had, and the Indians requested the tanker to come into Kochi port for investigations. And that was complied with. There was a lot of argument between the parties whether India, in a sense, coerced the tanker. It had airplanes and frigates that joined the scene later. But ultimately, the court ruled that that had not been a question of coercion, that the captain had made his own voluntary choice to sail into port. And once in port, a couple of days later, the two of the head Marines were arrested and criminal proceedings commenced in India. Now, the incident took place in 2012, and in 2015, after diplomatic endeavors had not borne fruit, Italy brought an Annex 7 arbitration against India. Now, I'm not going to go too much further into the facts of the case. This is one, usually Michael and I are on the same side in cases, but this is one that we were on opposite sides. And I don't want to say anything that will get Michael too upset or vice versa. But there were a couple of interesting aspects procedurally about this case that I thought might be of interest. The first was that Italy requested provisional measures in front of ITLOS shortly after the application was filed. As you know, pending the constitution of an Annex 7 tribunal, ITLOS has jurisdiction to deal with provisional measures applications. And ITLOS issued an order in August 2015 setting out provisional measures, but not, contrary to Italy's wish, requiring India, pending the outcome of the case, to send the Marines back to Italy. Once the Annex 7 tribunal was constituted, Italy filed another provisional measures request on more or less the same lines. And this time the tribunal, the Annex 7 tribunal, again issued a separate set of provisional measures, but did allow the Marines to go back to Italy pending the outcome of the case, but still under the supervision of the Supreme Court of India, such that they couldn't leave Italy without the permission of India's Supreme Court. And I think this is one of the few cases, or the only one that I can think of, others may be able to, where we had 2 provisional measures applications before 2 different bodies, and not entirely consistent findings. The other interesting procedural matter involved the question of witnesses. Now, the facts in this case, particularly on the day of the incident, the shooting incident, and the 2 or 3 days afterwards, were very intensive. And the parties discussed these facts on an hour-by-hour and even minute-by-minute basis in some instance. And there were a number of key players, the captains and the tankers, the captain of the fishing boat that had been fired at and had 2 of his crew members die, a helicopter pilot from and a frigate commander from the Indian Coast Guard and naval authorities that had been in contact with the Enrique Lexi, the tanker. And it was the tribunal itself that requested 5 witnesses. The 2 captains of the Enrique Lexi, the captain of the fishing boat, and the 2 Indian, the pilots on a plane that had been circling the Enrique Lexi and on a nearby frigate. It was the tribunal itself, or the court, this was its loss, the tribunal itself that requested the presence of these witnesses in the testimony at the oral hearings, not the parties. And moreover, the tribunal established some very strict guidelines such that the parties were not allowed to have any contact with the witnesses before their testimony. And so the things like travel arrangements to get to The Hague, because the case is being heard in the PCA's facilities in the Peace Palace, those were all organized by this PCA so that the parties could have no contact with the witnesses. And I think
apologies, Rod, you have 1 minute left.
Well, I think this is an interesting development in terms of tribunals taking a proactive role in the management of hearings. Only on the Equatorial Guinea France case, I know Michael was involved in that case, it was brought under the Palermo Convention and the protocol, the optional protocol to the Vienna Convention on Diplomatic Relations. Probably the most contentious issue concerned the status of diplomatic premises. Does a receiving state have a right essentially to veto, or does it have to approve the designation by a sending state of diplomatic premises? France had protested diplomatic premises on the Avenue Foch, had not recognized that, and that was ultimately the court ruled against Equatorial Guinea, but it was on that matter, saying that as long as France had timely objected and its decision was not arbitrary or discriminatory, it had the ability to say no to those premises, not to accept them being diplomatic premises. But it was a 9-7 vote, and there's some fairly strenuous dissents in there that are worth reading. But I found that that was probably the most interesting legal issue that came out of that case. So I'll end there. Thank you very much.
Thank you very much, Rod. And I will give the floor to Davinia next to give us her comments on the Iran-US and Qatar cases.
Thank you, Loretta, and what a privilege it is for me to be on this panel. Thank you very much for this invitation. I should clarify at the outset that I am speaking today in my individual capacity as an adjunct member of the NUS Law faculty, and that my remarks draw only from information in the public domain. So my task is to walk us through the ICAO Council appeals judgments from July 2020. That's the third preliminary objections, or PO's judgment from February 2021. Those judgments all sharing a common political context, which was the Gulf crisis, and the Iran v. USA PO's judgment, which is also from February 2021. So first, the two judgments of 14 July 2020 in the ICAO Council appeal cases. These were appeals against decisions of the ICAO Council brought by the quartet, with Qatar as respondent. The fact that there were two judgments calls for a very brief comment. There were two judgments because two applications were filed, Saudi Arabia not being party to the International Air Services Transit Agreement, which was the basis of the second application. The court directed common action on both applications, and both judgments are in essence appeals from decisions of the ICAO Council under Article 84 of the Chicago Convention. And so to keep things simple, I refer here to paragraph numbers from the judgment in the Chicago Convention appeal. This case was a rare instance of the court's exercise of its appeal function under Article 84. This was only the second such instance in over 70 years. The first was over 50 years ago in the court's 1972 judgment in India v. Pakistan. In the present case, the court unanimously rejected the appeal in its first dispositive paragraph, affirming its 1972 case law on the scope of the court's appellate function. At the same time, the court commented that the ICAO Council should give reasons for its decisions so that the court would be, and I quote, best positioned to act under Article 84 in future. On the second dispositive paragraph, which essentially held that the ICAO Council had jurisdiction, again a quote, to entertain Qatar's application, the court voted 15-1 with a dissenting vote from Judge Ad hoc Berman. There were three individual opinions in all from which we can draw further points of interest. I highlight just two now. First, Judge Gevorgian's declaration related specifically to the breadth of paragraphs 48 and 61 of the judgment, which in his view went too far in, quote, appearing to endorse an expanded definition of the Council's competence, end of quote. Along similar lines, Judge Ad hoc Berman said that the invocation of a wider legal defense by the responding state before the ICAO Council could not have the effect of extending or expanding the Council's competence under the Chicago Convention. Second, and relatedly, both Judge Gevorgyan and Judge Ad hoc Berman expanded on the institutional character of the ICAO Council, a point that paragraph 60 of the judgment touches on briefly. Here, Judge Ad hoc Berman saw a missed opportunity for the court to clarify the exact scope of Article 84, which he characterized as, quote, a difficult and troubling provision, end quote. If this is of interest, I recommend a look at paragraphs 5 through 13 of Judge Ad hoc Berman's separate opinion. So from this judgment in July, we move forward about 7 months to 2 successive days in early February this year. I take the judgment that was second in time first, not only because of the shared political context with the ICAO Council appeals I just described, but also because it has systemic implications for the court's relation with another part of the UN system, that is one of the UN human rights treaty bodies based in Geneva. This is the court's PO's judgment of 4th February 2021 in application of the International Convention on the Elimination of All Forms of Racial Discrimination, Qatar v. UAE, or the third case. That judgment required the court to determine the scope of the third prohibition against racial discrimination. Now, the questions before the court had already been dealt with by the third committee, the 18-member expert body responsible for monitoring states parties' compliance with CIRD. The committee had done so once in 2004 in General Recommendation 30 on discrimination against non-citizens, and in 2019 with specific reference to Qatar and the UAE, when the CIRD committee decided that Qatar's communication did fall within the CIRD. By an 11-6 majority, the court found that it had no subject matter jurisdiction over Qatar's application, diverging from the CIRD committee by holding that the term national origin does not encompass current nationality, and that even if proven on the facts, Qatar's indirect discrimination claims based on national origin did not fall within the CIRD. I think the range of views in the 6 individual opinions appended to the judgment shows that there were no easy answers to the questions before the court, a situation perhaps foreshadowed in the compromise formula of the relevant CIRD provisions themselves. Judges Yusuf, Sebutinde, Robinson, and Bandari disagreed with the court finding on national origin. Judge Iwasawa agreed with the court on national origin, but disagreed with the court on the indirect discrimination claim. Notably, as others elsewhere have also pointed out, Judges Sebutinde and Bandari applied the same methodology as the court and Judge Iwasawa to interpret the term national origin, but reached a different result. 5 of the 6 individual opinions commented on the judgment's non-engagement with the detail of the CIRD committee's normative output. Judge Yusuf thought that when dealing with the indirect discrimination claim, the court had asserted a view on questions of fact, which could only be established at the merits phase. This last point makes for an interesting comparison with the approach that the court took in the PO's judgment it issued in another case just the day before, on 3rd February 2021, on the US POs in alleged violations of the 1955 Treaty of Amity, Economic Relations, and Consular Rights, Iran v. USA. And that's the last judgment I'll cover now. The court dismissed those POs, so this case is now in the merits phase. The court was unanimous on 3 of those 5 POs and voted 15-1 to dismiss the remaining 2 POs as to admissibility and based on Article 20, Paragraph 1B of the 1955 Treaty, with both dissenting votes there coming from Judge Ad hoc Brower. Judge Tonka appended a declaration. There are several points of interest in this case, including the political backdrop of the US withdrawal from the JCPOA and the likelihood that this may be the last case before the court on the 1955 treaty, which has been terminated. But I'll highlight just 2 points for now. First, the court's treatment of the US argument about the scope of the 1955 treaty in relation to what the US called third country measures was a subject matter of Judge Tonka's declaration. Judge Tonka thought that the matter had been argued sufficiently for the court to resolve the matter in the jurisdictional phase, and contrasted the court's approach here which was to say that this PO raised legal and factual questions which were properly a matter for the merits, see paragraphs 81 and 82 of the judgment, with the approach taken in oil platforms and certain Iranian assets, cases involving the same parties and the same treaty. We here, as indeed others elsewhere already have, can also compare the court's approach here with the approach taken to Qatar's indirect discrimination claim in the third case, which I've just described. Second, if you have been following recent cases before the court in which one party has invoked abusive process, you may find it interesting to look at Judge Ad Hoc Brouwer's dissenting opinion, in which he lays out the history of the doctrine before international courts as part of his explanation for his dissenting vote on the operative paragraph relating to the admissibility of Iran's application. I'll stop here for now. Back to you, Loretta.
Thank you very much, Davinia, for keeping so well to the time. I don't know, we have 1 minute left on the time that was originally allocated to us.
Loretta, sorry, Nilofer has actually said, please go ahead till 4:55. So we have 5 minutes.
Okay,
Yes.
what I was going to ask you is if there are any questions from the participants. I see none I see one now. Okay, there is one from Sharon says
Yes.
to Sir Michael.
Yes.
And will you read that, Tara?
Yes, sure. Sir Michael, is it likely that the present junta government led by Senior General Min Aung Hlaing will present itself for the next hearing? And the ICJ's response to the junta will be instructive to many governments who are under pressure not to recognize the government. That was a question mark.
Yes, well, that's a very interesting question. And I look forward to seeing what happens. But I don't think I'm going to comment on that. I'm not involved in the case, and even if I was, I wouldn't wish to comment on that matter. But it's something that, in a sense, I foreshadowed, and I look forward to with interest. Sorry, I can't answer the question. Thank you.
Thank you, Michael. There appear to be no further questions. I don't know if anyone has a question. Rod appears to have a question.
It's not so much a question, but I just wanted to mention again, because I think this is going to come up in cases. It came up in the Chagos arbitration. It probably should have come up in the Suriname Guyana case, and it flows from Enrique Lexi, and that's the interface between Articles 288 of the Convention dealing with jurisdiction and Article 293 dealing with applicable law, and the question of an Annex 7 or a tribunal or court dealing with the Law of the Sea Convention, dealing with incidental questions that may not be dealt with, having jurisdiction to deal with incidental questions that may not be dealt with in the convention itself. One of the big questions in the Italy-India case was, did the Marines have immunity? And a number of provisions of the convention were put forward to support that proposition, but the tribunal said no, none of them deal with the question of immunity. The only question of immunity is in the convention are Articles 95 and 96 on warships or ships on government service, non-commercial government service. But the court said that this issue of immunity, that you couldn't determine which state had jurisdiction over the Marines without determining the immunities question, and thus it was an incidental question, and they assumed jurisdiction over it. So this is, I think, it is going to be interesting going forward, is how far do tribunals dealing with the Law of the Sea Convention get into incidental questions that may not be directly regulated by the convention themselves, when under Article 288 their jurisdiction is over the disputes over the interpretation and application of the convention. So I flagged that point. I would say that regardless of whether you agree or not with the result, the dispute between Italy and India wouldn't have been solved and wouldn't have been resolved unless that issue had been answered, which it was.
Michael, since you were also involved in the case, would you like to provide a comment to what Rod just said?
Well, only to say that I think he's hit the nail on the head with this case and many others. This whole question of what's covered by jurisdiction to determine a dispute concerning the interpretation or application of a convention comes up so often, and there really isn't any clear guidance on the subject. The various blogs and comments on the Enrique Lexi case have questioned what the tribunal did. Personally, I fully convinced the tribunal was correct because it agreed with what I'd argued. But nevertheless, I do agree with Rod. This is a very interesting point. Since I have the floor, I'd just like to mention one aspect of the Qatar UAE case under the CIRD, which Davinia mentioned. You may recall that just before judgment was given on the 4th of February this year, the countries concerned announced that they'd reached a political agreement to suspend all proceedings between them. Yet a few days later, the court gave judgment in this case. I don't know the facts behind this or how this came about, but it's very interesting. Can you indeed ask a court to suspend proceedings as opposed to agreeing to terminate proceedings before a court? And what happens if you do it at the last minute, just before a court is about to give judgment anyway? It reminds me of a case before the European Court of Human Rights, which was all about the right to property in Gibraltar under the first protocol. On the day on which the court was about to give judgment, or maybe the day before, the United Kingdom informed the court that we hadn't actually extended the first protocol under the European Convention to Gibraltar. So it didn't have any jurisdiction in the matter. And there the court agreed, it just didn't give judgment. It's a bit late in the day for the United Kingdom to realize this, but we did, and we thought we had to inform the court. And the court just didn't take the matter any further. So the question of what happens when at the last minute you tell the court something is a very interesting one, I think. Thank you.
But I shall not comment on that, since I may be aware of what was going on, since I was counsel for Qatar in that case, but it was a very interesting aspect, and certainly something that we'll see again, I'm sure, as states may or may not settle disputes or ask for suspension rather than termination. We shall see how things evolve. But I see now that we are over even the extra time that Nilofer had very kindly granted to us. So I give it over to Tara. Thank you very much, all of you, for a very interesting discussion, very thought-provoking. And I look forward to seeing you again in person very soon, hopefully.